Many landlords assume hiring an attorney means preparing for court. In reality, most of the work that matters happens long before a case ever gets there. When a landlord reaches out, the first step usually isn't filing anything. It's reviewing what's already happened. We look at the lease, the notices that were served, the timing, and how the issue developed. We review communication, payment records, documentation of violations, and whether each step followed the rules that apply in San Francisco. That review matters because landlord-tenant law isn't forgiving. Small inconsistencies can limit the options available later. One of the most common misconceptions is that being right on the facts is enough. Before court, the focus is whether the process supports the outcome you're seeking. If something was done out of order, served incorrectly, or documented inconsistently, it needs to be identified early. Sometimes it can be corrected. Sometimes it can't. But ignoring it almost always makes things worse. This is also where attorneys help landlords decide what happens next. That doesn't always mean moving forward aggressively. In some situations, the right move is to pause, correct course, or strengthen documentation before taking formal action. Another part of the work before court is setting expectations. We help landlords understand realistic timelines, potential risks, and what this jurisdiction actually requires. For experienced landlords, this early phase is often where legal counsel provides the most value. It's about making sure the foundation is solid before anything is filed, rather than trying to repair a case once it's already underway. Most cases that go off track do so because of issues that could have been addressed earlier. If you're dealing with a tenant issue and aren't sure whether the groundwork has been handled correctly, that's usually the right time to get guidance before court becomes the only option.